Hi everyone, this is Justinian Lane of Justinian Associates, and I have with me Dustin Fox and Erik Walker. We got some exciting news to share with you today. We're very happy. You might have seen the firm, one of our clients, Miss Rachel Watkins, was featured as the lead story on CBS Austin affiliate, their 10 p.m. news. I can't express how happy that I am that we were able to do some certain things for her. It was a really compelling case that the injuries that she had. She's a very unique woman. Can you talk a little bit about Rachel and her case?
Yes, actually, this was a broadcast on the Friday 10 o'clock news on CBS Austin, KEYE. That was September 22nd. And the woman's name was Rachel Watkins. Rachel is a blind quadriplegic. So as you can imagine, she has a great deal of difficulties getting around. She was taking a MetroAccess bus around Austin to run an errand or two. MetroAccess is an affiliate of the bus company in Austin that provides exclusively services for the disabled. And they have various locking apparatus that they put on their buses to hold wheelchairs in place. And the bus driver locked Ms. Watkins' wheelchair in place as he drove around Austin. She was sound asleep, and at one point he took a very sharp left turn. Her wheelchair came out from the locking mechanism. She landed on the ground. Her head missed the bus rack, the metal bus rack, by just an inch or two, and the chair landed on top of her. This chair was designed to serve the needs of a quadriplegic, in particular, someone with the kind of disability that Ms. Watkins had. It was a $40,000 chair, and as a result of this accident, the wheelchair was totaled, and Ms. Watkins was severely injured. CapMetro, who runs the bus, the transportation company with whom they had contracted to manage the buses, both denied liability. There was a fight over who was ultimately responsible, whether it was the people who ran the bus or the company that manufactured the locking mechanism that apparently failed in this instance. And no one would pay for Ms. Watkins' wheelchair. And as a result, she had to get a rental chair that was not geared for the needs of a quadriplegic. It broke down more than 5 times over 5 months. It was very old, decrepit, and it exacerbated her injuries dramatically. And so as we were pursuing litigation, which is a very slow process, we ultimately decided this is a strong public interest story. Let's get the news media involved. So we contacted a number of news organizations, and KEYE TV agreed as the CBS local affiliate to do a story on this. And as a result of that story and the work that the attorneys in this office did, CapMetro has agreed to pay for a new wheelchair geared specifically toward Ms. Watkins' needs. It was through contacts that Dustin here had with the media that we were able to get that story broadcast and get this great result for Ms. Watkins.
Yeah, it's one of the advantages is if you hire a firm with resources like ours is there was a number of steps that had to be taken to have this wonderful outcome, and we're very grateful that CapMetro decided to do the right thing and pay for the wheelchairs so Ms. Watkins can stop suffering. We took several steps to get this outcome to happen. First thing we did was we know how to get the film footage from the actual the bus that was in question. So one of our lawyers got a copy of that film footage, and we took it to our video guy at our in-house studio, who was able to put the video in a broadcast-friendly format, and I think that had a lot to do with why the media was interested in this case. We'll show the video here, and you can see it's very compelling. It's just tragic what happened with the wheelchair falling on her like that. And Dustin does a lot of community relations and has a lot of contacts in the community. So how did that work for you, Dustin?
Sure. I mean, that is, like what you guys already mentioned, that's one of the biggest advantages of hiring a firm that has resources like this. I maintain tons of contacts, and I was able to give Erik Walker, I don't know, about 3 dozen emails for investigative reporters in the local area. Luckily, CBS Austin was able to reach out to Mr. Walker and take the story first. And like JC and Erik both mentioned, this has been a fantastic result. This is the type of case that you become a personal injury attorney for. And these are the type of results that really make you proud to do this type of work.
Absolutely. And as Erik said, one of the things that we don't like about our job is how long the litigation process takes. If we could get cases resolved overnight, we absolutely would. But the court system doesn't work that way. Fortunately, the court of public opinion sometimes does work that way. And literally overnight, after CBS Austin broadcast this story, one of our attorneys was contacted by CapMetro, and what the news coverage sparked them to do the right thing. We're very pleased with this. This was a wonderful decision. And there's some complicated legal issues in this case, as Erik was talking about. CapMetro contracted with another company that runs the bus. On the bus is a piece of equipment manufactured by another company. Who is at fault? We don't know who's at fault. The jury is going to make that decision. But CapMetro decided that ultimately, since it's their bus line, they're going to do the right thing and make sure Ms. Watkins has a wheelchair. We're very grateful for that, and we, of course, are not going to take any kind of a fee for anything related to getting the wheelchair. The important thing for Ms. Watkins now is that she is going to be able to go forward with the wheelchair designed for her disabilities, and her life is back to normal as it can be after suffering the injuries that she did. So it's nice that even though we have some serious disagreements about who's at fault and what the responsibilities are, the right thing happened, that the person who's not at fault, her life is back on track. Now, one of the issues that we anticipate that will come up in the trial from Ms. Watkins is something that comes up in every case, is admissibility of evidence. The video that you saw of her being injured on the wheelchair, we're absolutely going to want to show that to a jury so they can see what happens. Now, one of the first lawyers that I ever worked for back when I was still in college told me a story of his very first trial, that it was a personal injury case, that the liability was clear, and he lost. He lost his case because he didn't know how to get any of his evidence admitted. So the jury ruled against him because he had all of his documents and everything lined up, ready to show them, but he couldn't present anything to them. So he admitted that he went home and he cried that day. And he studied the laws of evidence to make sure that that would never happen again, and he became a very successful attorney. So the laws of evidence are not exactly straightforward. There's not exactly what you would think they'd be. We can't just say, ladies and gentlemen of the jury, here's this video. Erik, can you talk a little bit about how we go about getting documents and videos admitted to a jury and how that whole process works?
Yeah, there's really two issues that relate to the admissibility of secondary materials, documents, videotapes, photographs, drawings, etc. One is the issue of authentication or authenticity. You have to prove that the document is what it purports to be. I remember when I was a law clerk working at a firm one summer, I was working for a partner who really didn't care too much for me, and he asked me to go out and draft a motion for summary judgment, a motion to take the case away from the jury and to rule in our favor, based on a contract between this consumer that was suing our client and the company that we represented. This was back when I was on the dark side of the force and represented corporations against people, as opposed to what I do now. And the contract was fairly straightforward. It exempted the company from liability for really any injuries, even caused by their own negligence. And as required by law, the language of indemnity was in bold letters, all caps, and highlight and made in a font much bigger than the rest of the contract, so that anybody could see it. And the law is that when a company sees language like that, they recognize it, and if they sign the contract, then they can't go sue the company for negligence in making the product. And so I researched that, got all the cases together, and attached the contract to this motion and gave it to this guy, thinking I'd done a great thing. They were going to offer me a job. I'd be set as an attorney. And he looked at me and said, "This is nonsense. There's no evidence here for this motion." And I said, "Well, I attached the contract to the motion." He said, "That's just a piece of paper. It's not even coming into evidence." And what he meant by that was, I didn't have any proof that the contract was what it purported to be. An actual contract signed by the individuals whose names appeared on the contract, that it was a true and correct copy of the document that they actually signed. A number of things could be true. One is the signatures could be forgeries. They could be from someone else. The pages of the contract could have been altered. Different pages could have been inserted such that while the signature page may be valid at the end, the pages preceding it may not be valid. So you have to prove that the document you're trying to introduce is authentic, and you do that through steps of authentication. Generally, all you need is testimony from someone saying, this document or this videotape or this drawing or this photograph, this computer re-imaging is a true and correct copy of the original, and that the signatures that appear, if it's a document, on the document are true and correct copies of my signature, and I got the document from the person whose signature appears in the other blank. Something of that nature that will suggest that the document really is what it purports to be. The testimony can come in at trial from the witness who signed the document. It could come in a deposition that you take before trial, or it could come in an affidavit that you get the person who signed the document to sign in front of a notary public. There's various ways you can get the testimony in. One thing to remember if you ever are representing yourself in a lawsuit is in federal court and a number of state courts, you don't have to have an affidavit to prove things up. You can actually have a declaration where you declare under penalty of perjury that the contents of the piece of paper are true and correct, and that substitutes for an affidavit that a notary public has to sign. Some of our clients who live out in the country have trouble sometimes getting to banks or other places where notary publics are, and that's a good thing to know in the back of your mind. If you're in federal court and courts outside of Texas, you can sometimes just create your own paper, and as long as you promise under penalty of perjury that the contents of whatever you're signing are correct, you can use that in place of an affidavit. But the state of Texas and its courts require an affidavit. The other issue is something called hearsay. You've probably heard that term used on Judge Judy or some of the other lawyer programs. Basically, what it says is that out-of-court statements by witnesses are generally not admissible if you're offering the statement to prove the truth of what the statement is. So if somebody were to say, I saw that automobile accident and I saw driver A run the stop sign and hit driver B, if you tried to introduce a written statement from a driver to that effect, maybe the driver sent you a letter as the lawyer, or maybe the driver filled out a report at the police department, that statement would be inadmissible. It is an out-of-court statement that you're offering to prove the truth of what is said in the statement. You have to overcome hearsay. In other words, your opponent in a lawsuit generally has the right to cross-examine anybody who you present testimony against them from. So if I were to introduce that driver into the courtroom and have the jury listen to him say, I saw driver A hit driver B by running the stop sign, my adversary, my opponent in that case, would have the opportunity to cross-examine him and to try to show that he's wrong, that his memory is incorrect, that he's not a credible witness. Maybe he's had convictions for fraud or forgery, and those would all bear on his credibility. But they can't do that if I introduce a piece of paper into the courtroom. You can't cross-examine a letter. You can't cross-examine a police report. And so the general hearsay rule is that any out-of-court statements are inadmissible, but there are exceptions. And one of the key exceptions is something called the business records predicate. And basically what that says is that if you're able to establish that a document is a business record, you overcome the hearsay objection. So a police report, for instance, could overcome the hearsay objection. You have to essentially establish that the document was made at or near the time of the matters it records by someone with knowledge of the matters stated in the document, and it's in the regular course of the people's business to keep and make such records. Once you've established those four things, at or near the time, by someone with knowledge of the matters, and it's in the regular course of the business to make and keep such records, you can get certain business records into evidence over the hearsay objection. Now, I talked a long time about that. Basically, those are the two main things you have to do to get documents into evidence. But if you don't do either of those two things, you run the risk of the court not letting you use the material.
And then the evidence would never come in, and we'd have nothing that we could do to present it. Now, Erik gave you like a thimbleful of knowledge on the hearsay rule. It's one of the more complicated rules of law for a lot of people. I know we spent a lot of time on it in my evidence class. Do you remember your evidence class?
Yeah, I mean, honestly, that was one of the tougher subjects, the hearsay rule. It's difficult to wrap your head around, and then you have hearsay within hearsay, which we don't probably have time to go within right here. But
no one wants to hear that.
Yeah, it can get real hairy.
Yeah, I remember in evidence class, I was having a little difficulty with the hearsay rule. So, you already have your evidence textbook that's like this thick. I checked out a book from the library also about that thick, just on the hearsay rule and all of its exceptions and how to get through it. And it helped me a lot in the class and as I went over into the practice of law. The key thing is that if you don't know how to get your evidence admitted, you're going to have a very bad day at court. We obviously know how to get our evidence admitted if it's possible. And in this case, the video evidence from the wheelchair accident will be very useful. And in any other cases we have, there's documents that need to come in or videos or other sorts of things. Now, A lot of times, it's a very boring process for the jury because, as Erik mentioned, the word that a predicate, or you're having to lay the foundation, you have to go to a witness before you can talk about an exhibit, a document you want to put in. So what is this? And this is your affidavit? Is this your signature? Does this purport to be this? There's a bunch of questions you ask. So what we prefer to do, if possible, and the opposing counsel and the judge are okay with it, is we will stipulate to the admissibility of evidence beforehand so we can have it pre-marked and just talk about this is Exhibit 1. Otherwise, we have to go up and ask the court reporter, can you please mark this as Exhibit 1? We want to move it into evidence. And that's an important step. If you forget to do any of these things, then you're in a bad place. And these are, for lack of a better word, these are just traps in the law. If you have a complicated case, you probably want to have an attorney help you with this, because even going to law school doesn't guarantee you know how to get the evidence in. And there's multiple ways to get things in. As Erik mentioned, there's business records affidavits, and we do this all the time to prove that documents are authentic and that they're kept in the normal course of business. It's a very boring part of the practice of law, but it's a very important part of the practice of law. But just because a document, for example, overcomes the hearsay rule and should be admitted into evidence, that still doesn't automatically mean we get something into evidence. There's a phrase that has special importance in the law called something can be more prejudicial than probative. And do you want to talk a little about that, Erik?
Yeah, you have documents that, or it can be testimony from witnesses, any piece of evidence. In determining whether to admit it into the trial, the court has to evaluate the relevance or the benefit, the probative nature, meaning how much this evidence goes toward proving an important fact of the case versus the amount of unfair prejudice it would cause to another party. So, for instance, if you had a document that basically said that a particular witness, you were using it to show this witness is not credible because the witness owned a bunch of pornography, and when he was questioned by the police about his pornography stash, lied and said he didn't have any pornography, and you want to introduce the evidence to show the witness has a propensity to lie, the court would look at that and say, I have to evaluate the importance of that evidence with regard to the witness's credibility versus the prejudicial effect that evidence will have on a jury when they hear that the witness reads a lot of pornography. And probably in that instance, the court would find that the unfair prejudice of the testimony outweighed the probative value, because the evidence really contributes very little to the witness's credibility. Most people might lie about their porn collection if they had one. That doesn't necessarily bear on their credibility as a witness under oath in a trial. On the other hand, the prejudice, the angst and anger of a jury when they hear the extent of somebody's porn collection would be highly prejudicial. So that might be an example of evidence that, even though it's admissible under all the general rules of evidence, would be inadmissible because its prejudicial effect, its unfair prejudicial effect, outweighs its probative value.
And this is where lawyering really comes into play, especially if you have documents dealing with corporate liability. What did a company know? What did they do? There's always, we call them hot documents or smoking guns, whatever. I know in the asbestos world, there was a major brake manufacturer where a manager put in writing, I don't really care much about all this asbestos business. If you make a good living from asbestos, why not die from it? And we try to get that in to tell the jury, hey, look, wow, see, this company doesn't even care they're killing their companies with their products. And we typically aren't able to get that in because this guy wasn't that important in the hierarchy, but sometimes we are able to. So it all depends on your lawyering abilities. And I know, Erik, you've done a lot of work with this sort of thing in your pharmaceutical career. So is there any documents or anything you remember that you had to really fight to get in and either could or couldn't?
One of the documents in the hormone therapy litigation that we had to wrestle with, well, there were a series of documents. One of them was a document that said that we don't want to go back, by Wyeth, saying we don't want to study this product to determine if it causes breast cancer because, frankly, the studies would be costly and they might have results that prove to be embarrassing. And the defendants would argue that, well, that saying that we didn't want to be embarrassed, that's really going to prejudice the jury. And most of the judges said, yeah, it's going to prejudice them, but that's a pretty fair prejudice. You said it. Your executive said we don't want to study because it's going to be embarrassing. That's probably something the jury ought to have the right to know. It's a shame that he used that kind of language, but it is your person who used that kind of language. On the other hand, we had a series of handwritten notes from an executive that said it was at a meeting about the breast cancer risk of hormone therapy, and it was these handwritten notes were summarizing the contents of the meeting, and it said in big letters across the middle of the document, dismiss and distract strategy, keep U.S. press busy. And it was talking about how the strategy of the company would be to dismiss and distract people from the breast cancer risk and focus their attention on things like the mythical cardiovascular benefits of hormone therapy. We now know that combination hormone therapy didn't have those heart benefits, but at the time that's what they were claiming it did. Initially, some judges said that's a highly prejudicial document. We don't know whether that was just somebody pontificating, somebody making a suggestion that was rejected. But then we had a lot of other documents that discussed the dismiss and distract strategy later on that we found. And when you combined all those documents, other judges found that the probative value of the document outweighed its prejudicial impact. So it does depend a lot on advocacy. It depends on the context in which the document appears, other documents that might provide some support for what the initial document said. But it is a battle over balancing probative value versus prejudice and determining which outweighs.
Right, and we don't always win. Sometimes we have some really damning corporate documents that don't get admitted into evidence, and we wish we could talk about some of those things because there's some household names out there that you won't believe what they've put in writing, and we unfortunately wish we could show you those documents, but we're not allowed to. They're under protective orders. One of the wonderful things is, regardless of a protective order, if a document gets admitted into evidence, it's public and can be on the front page of the New York Times or anywhere else they want to put it. So on our public interest side of things, whenever we can get any document that reveals corporate misconduct or especially public safety hazards, we try to get that admitted into evidence so we can distribute it wherever it needs to go, so we can help let the public know what's really going on. And helping people is a big part of why we did get into the business that we're in. Erik used to work on the defense side, and now he works on the plaintiff side, and I know he's much happier doing that. And Dustin and I were talking just the other night when this happened with Rachel Watkins. I mean, you were pretty happy about this outcome.
Yeah, no, this is a terrific outcome. It's, like I said earlier, it's one of those cases that you dream about. You want to become a personal injury attorney to help people, and this really did make a huge impact in her life, and it will continue going forward. So, yeah, I mean, I couldn't have been happier about the results so far, and litigation is going to continue. So hopefully that trend continues.
And, we said that we're not taking a fee from getting her wheelchair back. And if you think about it, I think every one of us had a very good night's sleep on Saturday night when we found, or I guess it was actually last night when we found out that that CapMetro was going to pay for the damages. I had a good night's sleep Saturday too after I saw the video that the CBS affiliate did, which was such an excellent story. So we give up a few $1,000s in fees. It helps you sleep a lot more knowing that a blind quadriplegic woman will now have what she needs to function on a daily basis than it does to have a few $1,000s extra money. And that's just what being a plaintiff's lawyer is all about. Yeah, sure, it's nice to make some money, but that's not why we initially gained interest in the plaintiff side of the law. We wanted to work for plaintiffs because we wanted to help people who can't help themselves, the disenfranchised, the people who can't speak for themselves. We wanted to give them a voice and give them the opportunity to get justice.
That's absolutely right, Erik. And I was just reminded, I don't even remember which insurance company it is that their whole thing in their commercials is they say they want to make it right the way it was before the accident, and then they rewind the footage to show, see, now everything's back the way it was. Unfortunately, many times to get things back the way it was, you have to hire an attorney. Rachel Watkins trusted us to get her life back to the way it was, at least with her wheelchair, and we're so happy that we were able to help every step of the way, that CapMetro did the right thing, and we're so grateful for CBS Austin for giving the coverage that this story needed. You may see other stories from us in the news from time to time. I mean, obviously, we're not going to, hey, there was a car accident and this should get covered, unless it's a special case. So we want to thank everybody that was involved in helping Rachel out, and we look forward to working with her in the future to get a good resolution for the rest of her case. And if you've got a case that you think is a real wrong that needs to be righted and would like us to help with that, please contact us, and we'll take a look and see if there's anything that we can do. Thanks.